attorney, the client who sold his business and was then sued by the buyer. I alluded to this before. Okay, we represent closely held companies that have achieved real success. And what happens in closely held companies is that many times they get purchased by larger buyers, companies that are not closely held but regional companies, sometimes national companies. It's what all you guys probably dream about because you want to cash out and say, I made it. So what do you think happens when you sell to a regional or national buyer? They come in with high-powered attorneys. You should see the contracts that you're being asked to sign. Okay, they're more like books than they are like, a page or two. And what do you think is contained in those contracts? Pages and pages and pages of warranties and representations. Who do you think signs the contract? Not just the LLC or the company that's doing the selling of assets, but the owner of the company. Because if you won't put your personal signature on that contract, they're not certain that the warranties and representations are really true. And what do you think you have to say in connection with those warranties and representations? Not to the best of my knowledge, information, or belief, but I certify that the following is true and correct. What do you think happens when the buyer doesn't achieve projection? Sometimes buyers will say, we screwed up. We should have respected the relationships that the seller had with its vendors, with its customers, with its employees. The seller had that secret sauce, so to speak, that made the seller's company successful. The buyer comes in and says, I know better, we're bigger, we're regional, we're national. Forget about those little kinds of things. We're going to operate the company this way, but most companies, most buyers don't think like that. When they don't achieve projection, they say to their high-powered law firms, there's got to be a breach of one of those warranties and representations. There's pages and pages and pages. So here you are, you've cashed out, okay? You think life is great, okay? And what happens X number of months or years after the closing took place? You get served with a lawsuit from a high-powered law firm. Saying, by the way, you breached your warranty and representation and you owe us back the money that we paid you at the time of closing. If you're in that situation, what would you like to say? Okay, I have two choices. I either have to defend the lawsuit, hire a high-powered law firm of my own. Okay, what do you think you'd have to pay the lawyer? Even if you won, you've lost. Wouldn't it be great to say, go ahead and take judgment. Good luck getting to my assets. Okay, and if you've gone ahead and done your planning, whether it's putting the assets in your spouse's name, whether it's investing in an annuity, whether it's an LLC, or whether it's an asset protection trust, go ahead, have your fun, make my day. You won't get my assets. So I would strongly advise any client who sells his business, okay, to consider asset protection planning after the sale.